Part 2 of Chapter 27. We move to the Clayton Act, a subsequent act after the Sherman Act. It was aimed at specific anti-competitive or monopolistic practices that the Sherman Act didn't cover. 4 distinct forms of business behavior are declared illegal but not criminal. It's illegal only if it tends to substantially lessen competitive or to competition or to create a monopoly power. One of those things is price discrimination, charging different prices to competing buyers for identical goods. In order to violate this section, the seller must be engaged in interstate commerce, the goods must be of a like grade and quality, and the goods must have been sold to 2 or more purchasers. The price discrimination must be to substantially lessen competition, to create a monopoly, or to injure the competition. These can arise from discounts, offsets, rebates, allowances, favorable credit terms, delivery, or freight charges given to one buyer over another. Defenses to price discrimination: if the seller can justify the price reduction by demonstrating that a certain buyer's purchases save the seller costs in producing and selling the goods, the seller will not be liable for price discrimination. Another defense: if the seller charged a lower price in good faith attempt to meet an equally low price of a competitor, then the seller will not be liable for price discrimination. Another defense is a changing market condition. A seller may lower its price on an item in response to a changing condition affecting the market for or marketability of the goods that are concerned in the activity. Section 3 deals with exclusionary practices. Sellers or lessors cannot condition the sale or lease of goods on the buyer or lessee's promise not to use or deal in the goods of the seller's competitor. Exclusive dealing contracts: sellers are prohibited from forbidding buyers to purchase products from the seller's competitors if the effect of that will substantially lessen competition or tend to create a monopoly. Section 3, this is the third prohibition: tying arrangements. The conditioning of the sale of a product on the buyer's agreement to purchase another product produced or distributed by the same seller. The legality of that depends on several factors. We're not going to get into those. Section 7 deals with mergers. Under Section 7, a person or business organization cannot hold stock or assets in more than one business when the effect may be to substantially lessen competition. Okay, a crucial consideration in merger cases is market concentration. Courts are going to consider other factors in determining if a merger violates Section 7, such as whether the merger will make it more difficult for potential competitors to enter the relevant market. Horizontal mergers: these occur between firms at the same level in the production and distribution chain. There are guidelines set by the Federal Trade Commission and the Department of Justice that guide in determining whether those mergers will be challenged by those departments. Vertical mergers occur when a company at one stage of production acquires a company at a higher or lower stage of production. Whether that's legal or illegal depends upon several factors. If it does not prevent competitors of either merging firm from competing in a segment of the market, the merger will be deemed to be legal. So obviously, this is just a kind of definitional approach to talking about antitrust law. These things are extremely, extremely complicated with a long line of history of statutory and case law that has to be applied. Okay. Interlocking directorates is another prohibition. No person may be a director for 2 or more competing corporations at the same time if either of the corporations has capital surplus or undivided profits at the level stated here, based upon the 2016 thresholds. They may have been increased since then. Not particularly relevant for this class, except to know that there is a provision prohibiting people from serving as directors on competing corporations under these particular circumstances. So that completes part 2 of chapter 27. The magic word for chapter 27 is monopoly.